All right, this is part two talking about employment law. Let's just say you have a discrimination case where your employer, if you were a woman, if you were an ethnic minority, um, just any one of the protected class, that allows you to file suit because you believe they terminated you because of those things. There are many things that you actually need to know about this, which will help you when you are discussing this with your lawyer that you choose. All right. The first thing you have to understand is that there's going to be state law, and then there's going to be federal law. And even federal law is going to be different based upon the case law in your circuit. Like here in Florida, we have 11th Circuit, which is Florida, Georgia, and Alabama. Okay, so there's many things in 11th Circuit, which is extremely conservative circuit, that's different than will be wherever you live. Now, for instance, okay, in our circuit, an employer, meaning that a supervisor and or your fellow employees get to basically call you a derogatory comment one time. So like for a woman, if you're called a bitch once, that's not frequent enough to warrant you being able to show direct evidence of discrimination. And for black folks, they even get a chance to call you the N-word once. But as long as it only happens once. If it happens once, that's still not really considered direct evidence. Now, you can try in order to be able to get it to be that by showing other things that go along with it. However, unless it actually came from the supervisor who is the one who made the decision to terminate you, you have to be able to prove that ultimately your job, your employer, is responsible for that person's actions. So when they actually, if it's not a supervisor, the employer needs to be told about it and give an opportunity to do something about it. Now, if it's the supervisor and they do it several times, at that point in time, then what you're looking at is the frequency, all right? You're looking at the severity, you're looking at whether or not it was humiliating. And so if you get called, out of your name, something ethnic like the N-word for a black person, or for a woman if you're repeatedly called a bitch, at that point in time, it is humiliating because there's case law that specifically states that, hey, you call a woman that is based upon the gender, and it is humiliating to a woman. So if you repeatedly call a woman that, then yeah, it can be considered direct evidence. Now that is especially so if you have the person who made the decision to terminate her is the one who was calling her that, right? But outside of that, you have to make sure that you have evidence that will show that, one, you knew about the discrimination, that the discrimination was severe enough, and the severity is objective and subjective. So you can't just say, well, in my mind, yeah, that was just enough. It needs to be objective as well, meaning that the average reasonable person would find that to be humiliating and severe as well. All right. So the courts are going to look at those things and say, well, you know what? It wasn't bad enough. And you're going to sit there and be amazed at the fact that you don't believe it. You can't believe that they believe that you should go through this. Fact is that depending on what it is, they might. So what you have to do when you're going through this is that you need to make sure that you reach out to a lawyer. Get a consultation. Now, when it comes to employment law, quite often lawyers don't do free consultations. The consultation may be a half-an-hour consultation. You may have to pay for it, maybe $100 and maybe a couple $100, but believe me, it's worth it, because quite often what you believe to be something that's a winnable case isn't. So you need to find out. And you may need to go and get several different opinions on it because you just don't want to believe it. But once you've got the opinions on it, then you can know what you need to do. But you always need to look out for your rights, to see what it is that you need to do, and just try to do the best that you can at making sure that your rights aren't violated and that you do everything necessary to keep your job and try not to, get into trouble when it comes to work. That's a difficult thing to do because what happens is that we have this thing in us that says, I know my rights. No, you don't. Because your rights are constantly changing based upon case law. So when you say, I know my rights, employer may laugh at you because they know that you don't. Because for the most part, they don't even know it. They have to contact their lawyer to see what the rights are now because they are constantly changing. Like in some cases, especially in our circuit, you have the right to treat a paramour, someone that you are dating, better than other folks as long as it doesn't involve quid pro quo. So that means that you can have your girlfriend working there and treat her much better than everybody, but as long as it's not because she's having sex with you, that's perfectly fine. And a lot of folks say, you got to be kidding me. And let me tell you what that's based upon. It's based upon the fact of most of the courts have stated that they don't want to interrupt the legitimate business decisions of the decision makers at businesses. They're not here to tell you how to run your business. They're just here to correct you when you do something illegal. So employers get a chance to fire you for no reason, bad reason, good reason, a ridiculous reason, as long as it's not an illegal reason. For the most part, with the exception of those who have contracts and things of that sort, and in certain states or areas, most of us are at-will employees, meaning that they can fire us for those reasons I stated, as long as it's not an illegal reason. So all of you people who believe, oh, well, they're not fair, the employer, oh my God, my boss just isn't fair to me. As long as he's not fair to you the same way that he's not fair to people of other races. Your boss has the right to be an ass. Don't work there. That's kind of the way that they see it. The court's not there to make them be better employers to you. They're there to make sure that they didn't do something illegal to you. All right? So the next time you think that something isn't fair, well, I'm going to call a lawyer. And you call a lawyer, and the lawyer says something you don't want to hear, and you're like, oh, you're just not a good lawyer. No, it doesn't mean that. It just means you don't understand that these rights that people keep trying to tell you have when it comes to employment law, they just aren't as vast as most people believe that they are, or as vast as they really should be, at least in, certain instances. So with that said, we'll talk again.